call.
Ms. Feynman, you're still under oath.
Ms. Feynman, did the Lake County Board of Elections and Registration have a meeting a few weeks ago to discuss the small precinct issue?
Yes.
And was there a court reporter who took down the statements made by the individuals who were at that meeting?
Yes.
Your Honor, if I may approach.
You may.
I'm handing you what's been marked as Plaintiff's Exhibit number 3 and ask you to review that document. Is this document a record of the proceedings held on July 15, 2014 before the Lake County Board of Elections and Registration?
Yes.
And on page, I guess the third page, but there's another page number 2, does it show the people who were in appearance at this meeting?
Yes.
And that includes the 5 members of the board, correct?
Yes.
Yourself and your Republican counterpart, Assistant Director Patrick Gabrione?
Yes.
And some election administrators from your office?
Yes.
And your 2 board attorneys?
Yes.
Including Mr. Wickham, who's here today?
Yes.
And then it says members of the public.
Yes.
Directing your attention to numerical page 25 in this document. Does this depict a portion of the meeting where the board began discussing Senate Bill Act 385 and this new legislation?
Yes.
Turn to, as you see at the bottom of page 25, that here Mr. Gabrione is making some statements and then continuing on to the top of page 26.
Yes.
Do you see where Mr. Gabrione, the Republican representative, states that you recall from the mandate that suggests that we look at all the precincts, address those that are less than 500?
Yes.
So Mr. Gabrione called this a mandate?
Yes.
And turning to page 33, see about the third way down where Mr. Gabrione is making statements again.
Yes.
And at the bottom of that page, there's further discussions and comments. He said, I didn't mandate this.
Yes.
I'm not part of the legislature.
Yes.
And then further on page 34, he makes some statements saying that this is a Republican or Democratic issue, correct?
Yes.
He says this is an American issue.
Yes.
And further on in the next paragraph, he says these are American voter maps.
In that same paragraph?
In the next paragraph.
Yes.
So Mr. Gabrione called the legislation a mandate, but then recognizing the legislation said it was an American issue,
Yes.
not a Lake County issue,
Yes.
but an American issue.
Yes.
Your Honor, I would move to admit Plaintiff's Exhibit 3 evidence.
Any objections?
Your Honor, these minutes, this transcript hasn't been approved by the board, so to the extent that it's being alleged as the official transcript and minutes of the board, we would check on this one.
Your Honor, we would stipulate that it hasn't been officially approved by the election board because they didn't meet last Friday, August 1st, pursuant to your temporary restraining order. However, it is a record that is maintained and was provided to me by Ms. Heyman at my request earlier this week, so I can gain an understanding of the election board's position and procedures with regards to this issue. So it is a public record. There is an exception, and we would request that it be admitted over objection.
Objection overruled. Submitted.
That's the witness.
Mr. Governor doesn't speak for the entire board, does he?
No.
And he doesn't speak for Lake County as a whole, does he?
No.
He doesn't speak for the state of Indiana, does he?
No.
No questions.
Thank you, Ms. Feynman. You may step down.
The plaintiff would call John Bunches.
Do you solemnly swear or affirm to tell the whole truth and nothing but the truth to the best of your knowledge? Please be seated.
So would you please state your name and spell your name for the benefit?
John Buncich, John-B-U-N-C-I-C-H.
And sir, are you a plaintiff in this case before the court today?
Yes,
And are you a plaintiff in an individual capacity or in some other capacity?
in my capacity as the county Democratic Central Job.
Okay, and when did you assume the role as chairman of the Lake County Democratic Central Committee?
I was elected June 28th.
Okay, so just approximately 6 weeks ago. And when did you become aware of this new legislation that affected just Lake County?
2 days later.
Okay, so that would have been Monday, June 30th?
Correct, yes.
So approximately 1 month prior to the filing of the lawsuit, correct?
Correct.
And did you have communications and conversations with members of the Board of Elections and Registration regarding this?
Yes,
This legislation? Did you also have communications with the employees of the board, including Ms. Payment, regarding this legislation?
yes.
What was your understanding with regards to the board's plan to implement and follow through on this legislation?
Object to the extent, but I don't think he's laid a proper foundation for his knowledge of what the plan may have been for the board.
Do you want to?
How long were you ready?
Okay.
Were you informed that the board planned to reduce precincts?
Yes.
And were you given proposals that had been created within office and or by members of the board?
Yes.
And based on those communications and the documents that you reviewed, what was your understanding that the board planned to do at the meeting on August 1st?
I was given several documents, worksheets, whatever, and it showed that the plan would be that Lake County would lose anywhere from 40 to 80 precincts.
And if those precincts would have been merged, then would you have been charged with the responsibility of deciding between elected precinct committeemen who stayed in office and who didn't?
There would be several precinct committees that would lose their office at the end. just been elected for May 6th.
That's the witness.
Cross-examination.
I believe you testified, and correct me if I'm wrong, that it was your understanding that the Board of Elections was going to reduce the number of precincts in Lake County. Is that accurate? As your testimony?
Yeah.
Did you speak to every member of the Lake County Board of Elections regarding the small precinct legislation?
Not the actual board members.
Correct.
I spoke with, yes.
You spoke to every single member of the board about this small precinct legislation?
Yes.
Okay. I have no other question. Oh, wait. No, I have no.
Sir, directing your attention to Exhibit 3, which is before you today. Ask you to turn to page 3. You can see at the bottom of that where Chairman Kevin Smith recognized you as the new chairman of the Democratic Party.
Yes.
So you were in attendance at this meeting on July 15th.
Yes.
So you would have had an opportunity to speak with all the board members before and after this meeting regarding this legislation.
Yes.
No further questions.
Any recross?
I'm sorry.
Any recross? Go ahead.
Nothing.
Nothing? Thank you, sir. You may step down.
Your Honor, the plaintiff's rest.
Okay.
The defendants do not, the state defendant does not have any witnesses that can be
Okay.
Your Honor, the analysis for whether legislation is constitutional or unconstitutional begins with determination of whether the legislation is special or general. If the legislation is general, the court's constitutional inquiry ends. But if the legislation is special, the courts must determine whether there are unique characteristics or circumstances of the county or class that justify the special or local nature of the legislation. It is evident that the 2014 legislation establishing a small precinct committee to determine if precincts can be consolidated is special legislation. The question becomes whether any unique characteristics of Lake County justify the consolidation of precincts in which there are fewer than 500 active voters. The reasoning stated in the statute is election cost savings, which seems to have general applicability statewide. There have been no justifications within the statute and applied in the statute or provided to Your Honor today, which makes this legislation permissible special legislation. To obtain a preliminary injunction, the moving parties typically show by preponderance of the evidence four things. The movement's remedies at law are inadequate, thus causing irreparable harm pending resolution of the substantive action. The movement has at least a reasonable likelihood of success in trial by establishing a prima facie case. The threatened injury to the movement outweighs the potential harm to the non-moving party resulting from the granting of an injunction, and the public interest would not be disturbed. Now, the state defendant appears to be focused on the fact that they're saying that there is no harm yet because the election board didn't meet. But that's the very reason why we have a temporary restraining order, so the harm is not in fact occurred. And, Your Honor, if I may approach with a copy of Sadler v. State, 811 Northeast 2nd, 936, which is an election law case out of Indianapolis from 10 years ago. And there's some discussion regarding preliminary injunction. And if you will see on actual case law, page 953, it discusses to obtain a preliminary injunction, those 4 items that I just laid out for the court. But it goes on to say, however, when the acts sought to enjoin are unlawful, the plaintiff does not make a showing of irreparable harm or a balance of the hardship in his favor. We're not just saying that this legislation is unlawful. We're saying it's unconstitutional. It violates the state constitution of special legislation. 7, the state goes on to agree that the elimination of 2 prongs eases the burden on the party seeking the injunction. In the per se rules and code, the court has determined that the defense action violated the statute, or in this case the Constitution, and thus the public interest is so great that the injunction should issue regardless of whether the plaintiff has actually incurred irreparable harm or whether the plaintiff will suffer greater injury than the defendant. And that's what we are asking you to do. And we're asking you to enter the preliminary injunction by finding that not only is this unconstitutional, and therefore we only have to meet 2 of those prongs. As you heard from testimony from Mr. Zicky from the Indiana Election Division, and is shown by not only Plaintiff's Exhibit 1, but Plaintiff's Exhibit 2, the summary document, there are a number of counties in the state of Indiana that have they have precincts with fewer than 500 active voters. In fact, there's only 3 counties in the state that do not. There are also, I believe the testimony was, 29 of the counties in the state of Indiana have 33% or more of their precincts with fewer than 500 active voters. That's the percentage that Lake County has. So Lake County is on par with at least approximately a third of the state with regards to the number of precincts it has with fewer than 500 active voters. There's nothing unique about Lake County that requires this special legislation. As you heard, all of the precinct committeemen and one people testified, they were all elected in May of 2014. It is a position that is political in nature, but it's also governmental in nature. They have governmental responsibilities of filling vacancies, office vacancies, state legislative vacancies, circuit vacancies, county, city, town, township. They have governmental responsibilities. The list of those individuals is kept in a governmental office here in this building, or in an adjacent adjoining building. Those people have the governmental and administrative function of filling office vacancies, and they were just elected for a 4-year term and cannot be removed for a single term. And you heard testimony from the chairman, the plaintiff representative on behalf of the whole party. He just learned of this issue, and to his knowledge, the plan was in place to reduce these precincts, and that's why we took action. So the plan was to implement this reduction and we were on at the 11th hour of facing this. So that's why we filed the application for a temporary restraining order. Just to reiterate some of the statistics by percentage, Lake County has 33% of its precincts with fewer than 500 active voters, but there are 29 counties in Indiana that have the same, nearly a third of the state. Among the most populous counties, Allen County has 24% of its precincts with fewer than 500 active voters, Johnson County 26%, and York County 22%. Just by sheer number of precincts, Allen County has 81 precincts with fewer than 500 active voters, Marion County 65, Johnson County 35, Hamilton County 28, and St. Joseph County 24. Out of the 5,324 precincts in the state of Indiana, 1,109 of those precincts have fewer than 500 active voters. That's 21% of the precincts in the whole state. Yet this legislation doesn't apply to the whole state. It just applies to Lake County. These facts prove that fewer than 500 active voter by precinct characteristic is not unique to Lake County alone. Section 39 of Central Vote Act 35 is unconstitutional special legislation legally targeted at Lake County and Lake County voters law. The potential cost benefit from consolidation is not unique to Lake County. Clearly, there are budget constraints across the state. It's unknown by the language of the statute, and certainly not implied in the statute, why Lake County alone needs to save money with regards to election costs and not the other 91 counties in the state. There have been recently a couple of cases regarding unconstitutional special legislation that I would just like to bring to the court's attention and provide you and opposing counsel with, and that is outside chapter of Pi Kappa Phi fraternity versus auditor of Marion County or Monroe County, which is 849 Northeast 2nd 1131 Indiana Supreme Court of 2006. Copy to the Attorney General's office, and additionally, the Kinsey case out of South Bend, which is 781 Northeast 2nd 683, municipal city of South Bend versus Kinsey. So if I'm encouraged to provide
Yes.
Your Honor with the copy of these
Please.
cases as well. Belabor the points raised in these cases, but just to point out that these cases are recent Indiana cases that show the special legislation to be unconstitutional, and would ask Your Honor to be saying we ultimately not only grant our preliminary injunction, but as indicated at the beginning of this hearing in our request to have this be trial on the merits, grant our request, the plaintiff's request, that this legislation be found by you to be unconstitutional special legislation, thereby prohibiting the implementation of the same. Thank you.
Thank you, Your Honor. To address the plaintiff's final request, and first request here actually, it is very premature to consolidate this hearing and make it a trial on the merits. The plaintiffs only recently filed this case. We were only recently made aware of this. It's clear we have only just received 5 inches of documents that we haven't had the opportunity to review and analyze. We have only just received a transcript, and we haven't had even an opportunity to answer in this case. Our answers are due. There are grounds for dismissal, particularly the Attorney General in this case. The Attorney General, it appears that he was named only because he enforces law, although his role as far as enforcing this particular law is unclear to us at least. The Lake County, the election board, hasn't voted on this, hasn't had an opportunity to address this lawsuit, and to say whether they would, what their position would be on this. So it is very premature to consolidate at this time. With respect to the request for a preliminary injunction, that also was premature, as in this whole case. The plaintiffs prematurely filed this case based on pure speculation. That's been confirmed by the plaintiff's own witnesses time and again. They're not entitled to preliminary injunction because they're not going to suffer any harm. As plaintiffs pointed out, typically a preliminary injunction may only be granted as extraordinary relief that should be sparingly, only to be given if the plaintiff meets all criteria, including inadequate remedies at law, causing irreparable harm. If that is lacking, adequate remedies at law. The movement has a reasonable probability of success on the merits. The threatened injury to the movement outweighs potential harm to the defendant. The public interest is not in the service. First, with respect to adequate remedy at law, usually when we think of adequate remedy at law, we think about money damages. But an adequate remedy at law may also be administrative or other procedure. That procedure is laid out by the statute. This is a very detailed process for examining plans, to having a public debate about it, to hearing objections. And the plaintiffs could have a role in all of these steps. Instead, they want to circumvent that whole process and frankly stifle public debate about this. The statute lays out that a small precinct committee should be established, and it would propose something to the election board. The election board adopts a proposal. It doesn't say the proposal. It just says some proposal may be shall be adopted. Then that plan gets submitted to the election division, and then the election division may hear objections. If there are objections, then there's a provision there. We've got a long ways to go in this process before there's any consolidation. So there are adequate remedies at law, and on that last one, before the election division, the plaintiffs here had a chance to object to the plan. That will be heard by the election division. That's an adequate remedy at law. The plaintiffs had stated that we're at the 11th hour of this, and that was what prompted this lawsuit. The 11th hour would be when the consolidation would take place. We're well before that whole process. The harm here is not immediate. The harm would not be public debate about consolidation plans. The harm would be, if there were any harm, it would be actual consolidation where these plaintiffs would potentially lose their committee seats. That cannot take place until, at the earliest, January of 2015. And that's by the statute itself. In addition, no precincts may be consolidated until after election day this year. So even setting aside the statute we're dealing with, there's also a separate statute, but there's no consolidation at all until November. So again, there's a remedy at law here that should be allowed to run its course. Brings us to the next question, is whether the harm to the plaintiff weighed with the harm to the defendant. Here, the defendant at this time, as I mentioned, there may be grounds for dismissal here, the public and the defendant, the interests are the same, and there's an inherent value in public debate. That debate should be heard, the process should be allowed to continue, and again, this was brought prematurely. As far as success on the merits, admittedly, there's a lot of information here that needs to be analyzed, but plaintiffs' witnesses, a number of them have stated that they do not know the specific characteristics of other counties in relation to Lake County, and whether there's something peculiar about Lake County where this plan should be allowed to run its course. That is something that would come out, something that we would look at, but at this time, there's not a reasonable probability that, because it is clear that when you look at the numbers for Lake County and compare those to other large counties, such as specifically Marion County, where there's a wild discrepancy between the number of small precincts versus in Marion County versus Lake County, and even Allen County, there's a 10% difference between the two counties, approximately 10% difference between Allen County and Lake County that may justify this. But again, the legislation doesn't mandate a plan. It mandates a specific plan. It mandates a discussion about this. Whether there needs to be consolidation and how that consolidation may take place, that's something that the Lake County Election Board should be allowed to consider. And that would be the proper forum for this discussion. Again, the harm here is not the public debate. The harm here, if there were any, would be consolidation. And that's something that may not even happen at all. And if it were to happen, the earliest it would happen is January 2015. For that reason, also with respect to the plaintiff's argument that they don't even meet all the criteria for a preliminary injunction, they're begging the question here because there are competing laws here. There's the law, the statute itself, it's a question that does say that certain steps should be at certain dates, and that's one law. And then there's the open question that the reason why you're here is about the constitutionality of the statute itself. And that would be something that we will examine in this case as it proceeds. And to the extent that this statute applies only to the county, there is something, the evidence that was attached to our opposition, and the evidence that the plaintiffs provide as far as particular numbers. Lake County does have a high number of precincts with a small population, especially when you compare it to other urban counties with a high population. For that reason, we think that the plaintiff needs to meet all criteria for the preliminary injunction, not just the question on the merits. For that reason, we would ask that the plaintiff's motion for a preliminary injunction be denied.
So is it the state's position that the legislature passed a statute that's meaningless? I mean, there's no mandatory...
Well, it's not meaningless because it does have
So there is a mandate.
There is a mandate for a discussion of this. There's to discuss.
So once the discussion is done, they don't have to do anything? Is that what the state's position is?
No, then it goes to the election division, and then they may adopt it or reject it.
Okay.
If I may answer the question, I think the Attorney General's office maybe skipped over a step there. If you read the actual legislation, the committee, the small precinct committee, shall determine three things. Which precincts have fewer than 500 active voters? If compliance with the precinct boundary standards would prevent the combination of precincts with one or more adjoining precincts, and then the potential savings in the administration and elections resulting from the combination of those precincts. So they have to determine those three things. And then once they do that, no later than noon, August 1st, the Board of Elections and Registration, so 5 of the 7 members of the small precinct committee who have made these findings shall adopt a proposed precinct establishment order implementing the findings of the committee. Well, the Attorney General's office, so they don't have to adopt a specific one, but they have to adopt the findings. Legislative intent, to read the words in the statute. The Board of Elections and Registration shall adopt a proposed precinct establishment order implementing the findings of the committee. So whatever the committee finds, the board shall implement. That's the statute. I would agree with the Attorney General's office that it appears that this legislation has no teeth. There does not appear to be any penalty for complying with the statute, but that is for the Board of Elections and Voter Registration and their council to decide whether or not they want to sit on their hands and do nothing. Rather, the plaintiffs in this case sought to be proactive, realizing the day before this meeting was to be held, I believe at 9 in the morning on Friday, August 1st, they sought to join it. With regards to the 4 prongs of the preliminary injunction requirements as far as an adequate remedy at law, the suggestion that we had a remedy to stop this by having this debate and discussion. There was discussion. This committee was formed in June. There were meetings held. The new chairman attended the meeting in July, and this train was rolling down the tracks. And so there was that discussion. The understanding from the testimony you heard from the chairman and from Ms. Fain, the director of the board, there were going to be approximately 80 precincts that were going to be reduced. So they didn't have an adequate remedy before this rock started rolling down the hill. The plaintiffs needed to file this action to join it to stop it. As far as the suggestion that once this was submitted to the election division, that there could be some sort of objection filed with the commission and requiring at least 3 of the 4 commission members to affirmatively vote to sustain the objection. Well, the election commission is 4 members, 2 Democrats and 2 Republicans. So politically speaking, you have to get at least 1 member of the opposite party to vote with you. And I suggest to the court that that is not a realistic, let alone adequate remedy that the plaintiffs could seek after filing this lawsuit. Once again, the harm to the public greatly outweighs the alleged injury to the plaintiffs. I don't believe that balancing test needs to be done based on the case law that we provided you with today. But the injury to the election board is none. We've heard already that there's no teeth to the statute. There's no penalty from the state if they don't do anything. And as far as the public, I have not heard and not aware of any public outcry and support for this law. It wasn't requested by anybody in Lake County. To my knowledge, to pass this law was not brought to the attention of Ms. Fain or other individuals in Lake County. What do you think of this? What can we do to make this better? This is what we're thinking about passing. So I don't believe first that we have to do that balancing test, but even if we do, I don't see how there's a great harm to the public at large versus the harm to the plaintiffs who stand to lose their elected positions as precinct committee persons. The likelihood of success on the merits, the Attorney General has admitted that there's a lot of numbers and data, but he seems to fault the individual plaintiffs who are lifelong residents, most of them of Lake County, because they don't know what the precinct numbers are and what the percentages are in other states. Well, we wouldn't expect them to, but we don't need to do that. We had Michelle Bateman, who has worked for Lake County Board of Elections for a number of years and is not only familiar with our numbers, but with the numbers in other counties throughout the state based on her, conferences and communications with them and dealing with them. But on top of that, we had Michelle Brzezicki from the election division, who's worked there for almost 14 years. And we have 620 pages that precinct by precinct, county by county, who tells us what the numbers are. We know what the numbers are as of last Thursday, July 31st, when this was filed. So, and then we have the consolidated 3-page, more digestible version of those documents. And any way you slice and dice the numbers, the statistics are clear. There are numerous counties throughout the state of Indiana that have precincts with fewer than 500 voters. And that being the case, why just Lake County? Why does this law just apply to Lake County? Why isn't every county election board looking at their numbers and doing what they can to save money for their communities? But this legislation is just focused on Lake County and Lake County alone, and that's what makes it special legislation. That's why we believe we have a very strong likelihood of success on the merits, and that's why we believe this preliminary injunction should be granted, and your honor should determine that this is in fact special legislation and grant our request regarding the same.
Sure.
The plaintiffs can see that there's no teeth to this statute, which goes directly to the question of why the Attorney General has heard this case at all in terms of enforcing the law. The statute that the plaintiffs say is the key. The plaintiffs have been proactive based on pure speculation as to what the plan is, what a plan is, what could be consolidated, if there will be any consolidation. As far as any numbers related to the individual precincts, particularly in Lake County, that is something that the Lake County Board of Elections should be able to look at. They should be able to consider that. We should have a public debate about this. And that's why this election should be allowed to run its course, because there will be no harm to the individual plaintiffs if a preliminary injunction is not granted. In terms of the statute itself, Section 39 of the Act 385, the election board has to adopt it in order. It doesn't require consolidation. It says adopt a proposed precinct establishment order implementing the findings of the committee. Implementing, one of the definitions of implementing is to apply. So it takes findings of the small precinct committee and it applies those in an order. We don't know what that order would look like. We don't know. Again, there's a lot of speculation about how many numbers, about what plans are, but there is no order. The findings have not been formally presented to the board, and again, this motion is premature, and the motion should not be granted.
Okay. All right. Do we want to submit findings and conclusions? All right. How much time do you want to do that? $10 days enough?
10 days.
10 days?
That's fine, thank you.
All right.
Is it easiest to email those or
Disc. Submit them with the disc. All right, then we'll make a ruling.
Your Honor, would that be, so would we do on Monday, the 18th?
Right.
Your Honor, with that, we would request that the temporary restraining order that you granted last Thursday
Remains in effect. Continues until final decision. And if you wish to file any motions to dismiss certain parties or anything, you can file them with your findings and conclusions. Okay, anything further?